Hello students, welcome to the e-lectures. Our topic is the Negotiable Instruments Act 1881. This is Chapter 2 of Business Law, Ethics and Communication. Paper 2 IPCC exams of ICAI. I am CA Chiranjeev Sodhi, your mentor for this lecture. In this chapter, we will try to have basic knowledge of negotiable instruments, promissory note, bills of exchange, checks, types of instruments, liabilities of parties, accommodation bills, negotiation and assignments, discharge of parties. Dear students, before start, let's know about the abbreviations used in this lecture. NI means Negotiable Instrument. PN means Promissory Notes. BE stands for Bills of Exchange, and HDC means Holder in Due Course. What is a negotiable instrument? It is an instrument which is transferable by delivery like cash and is also capable of being sued upon by the person holding for the time being. The property in such an instrument passes to a bona fide transferee for value. Section 13 of Negotiable Instrument Act 1881 mentions only three kinds of negotiable instruments, namely bills of exchange, promissory notes, and checks. But it does not necessarily follow that there can be no other negotiable instrument than those mentioned in the Act. Now let's discuss the characteristics of negotiable instruments. Easy negotiability. These are transferable from one person to another without more formalities. Second is, transferee can sue in his own name without giving notice to debtor. The creditor can either recover this amount himself or can transfer his rights to another person. Better title to a transferee for value. A bona fide transferee of a negotiable instrument for value, that is, holder in due course, gets the instrument free from all the defects. First, written and signed. It is a written and signed document. There are some presumptions as to negotiable instruments. These are consideration that every negotiable instrument was made, drawn, accepted, endorsed or transferred for consideration. Second, that every negotiable instrument bearing a date was made or drawn on such date. Third is that every bill of exchange was accepted within a reasonable time after its date and before its maturity. Fourth, that every transfer of a negotiable instrument was made before its maturity. Fifth one, that the endorsements of negotiable instruments were made in same order as they appear on negotiable instruments. Sixth, that a lost negotiable instrument was duly stamped. Last but not least, that the holder of negotiable instrument is holder in due course. In nutshell, a negotiable instrument is a written and signed document entitling a person to a sum of money specified in it and which is transferable from one person to another, either by delivery or by an endorsement and delivery. Dear students, we must know what Section 31 of Reserve Bank of India Act says about negotiable instruments. Let's have a look. No person in India other than RBI or the central government can make or issue a promissory note payable to bearer. Second, no person in India other than the RBI or the central government can draw or accept a bill of exchange and a promissory note to bearer on demand. Next is a cheque payable to bearer on demand can be drawn. As per Section 13 of Negotiable Instruments Act 1881, there are three types of negotiable instruments: promissory notes, bills of exchange, and cheques. Let's discuss each type of negotiable instrument. Promissory note. In layman's language, it is a note containing promise. As per Section 4 of the Negotiable Instrument Act, a promissory note is an instrument in writing, note being a banknote or a currency note, containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. What are the essentials of a promissory note? 1. It must be in writing. This means that the engagement cannot be oral. There is no prescribed language for this. Even the word promise need not be used. What is necessary is that whatever language is used, it must clearly show that the maker is unconditionally bound to pay. Second, promise to pay. It must contain a promise to pay. Third, unconditional promise. The promise to pay must be unconditional. It must not depend upon the happening of some uncertain event. It must be payable absolutely. Fourth, it must be signed. The instrument without the proper signature will be incomplete and hence ineffective. Fifth, the maker and amount must be certain. And sixth, the pay must be certain. Like the maker, the pay of the promissory note must be certain on the face of the instrument. There are certain points which are to be noted. 1. Consideration need not to be mentioned. Second, place and date of making it not to be mentioned. Third, an undated instrument will be treated as having been made on the date of its delivery. Fourth, an antedated or post-dated instrument is not invalid. The second type of negotiable instrument is bill of exchange. A bill of exchange is a binding agreement by one party to pay a fixed amount at some fixed date. Bills of exchange. First of all, we must know how a bill of exchange ordinarily comes into existence. Suppose A sells goods worth rupees 1000 to B on credit and allows him 3 months' time to pay the price. A will draw a bill on B. After signing the bill, A presents it to B for acceptance Now A is the drawer and B is the drawee. And after acceptance, A is the drawer and B is the acceptor. The definition of bills of exchange is: a bill is an unconditional written order signed by the drawer directing a certain person to pay a certain amount of money to a specified person or to his order or to the bearer of the bill. Now we will see the essentials of a bill of exchange. It must be in writing. It must contain an order to pay. The order to pay must be unconditional. It must be signed by the drawer. The drawer, drawee and pay must be certain. You should remember that all these three parties may not necessarily be three different persons. One can play the role of two, but there must be two persons in any case. The sum payable must be certain, and the bill must contain an order to pay money only. Students, we have discussed promissory note and bill of exchange. There are several points of differences between them. Let's discuss these points. 1. Number of parties. In promissory note, there are two parties, maker and payee. But in bills of exchange, there are three parties, drawer, drawee and the payee. Second point of difference is promise and order. In promissory note, it contains a promise to pay, but in bills of exchange, it contains an order to pay. Third one is acceptance. A promissory note does not require an acceptance, whereas a bill of exchange requires acceptance. Nature of liability. The liability of the maker of a note is primary and absolute, whereas the liability of a drawer of a bill is secondary and conditional. Maker's position. Maker of a promissory note stands in immediate relations with the payee, whereas maker or drawer of bill is in immediate relation with the acceptor, not payee. Payable to bearer. A promissory note cannot be issued payable to bearer, but bill can be payable to the bearer. Notice of dishonour. In promissory note, no notice is needed, but notice of dishonour must be given by holder to all prior parties who are liable to pay in case of bills of exchange. Also, a promissory note can never be conditional, whereas a bill of exchange too cannot be done conditionally, but it can be accepted conditionally with the consent of the holder. It should be noted that neither a promissory note nor a bill of exchange can be made payable to bearer on demand. The third type of negotiable instrument is cheque. It is the most commonly used negotiable instrument. We all know that a cheque is a paper document by which we do the banking transaction. As per Section 6 of Negotiable Instrument Act 1881, a cheque is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of the truncated cheque and a cheque in the electronic form. All cheques are bills of exchange, but all bills of exchange are not cheques. Dear students, bills and cheques are similar in many ways. There are many points of similarity between them. Let's discuss. Regarding nature, both are the bills of exchange. Regarding parties, both have three parties, the drawer, dry, and the payee. Drawer and payee. The drawer and payee may be one and the same person in both the instruments. Written and signed. Both the documents must be written and signed. Unconditional order. Both must contain an unconditional order to pay a certain sum of money. Endorsement. Both the documents may be endorsed. What are the differences between cheque and bill of exchange? A cheque is always drawn on a banker, while a bill may be drawn on any person, including a banker. A cheque can only be drawn payable on demand, whereas a bill may be drawn payable on demand or on expiry of certain period. A cheque drawn payable to bearer is valid, but a bill drawn payable to bearer is absolutely void. A cheque does not require any acceptance, whereas a bill requires acceptance. A cheque does not require any stamp, whereas a bill of exchange must be properly stamped. 3 days of grace are allowed while calculating the maturity date in case of time bills. Since a cheque is always payable on demand, there is no any days of grace. Unlike cheques, bills cannot be crossed. And unlike bills, there is no system of noting or protest in case of a cheque. The drawer of a bill is discharged from liability if it is not presented, but the drawer of cheque will not be discharged by a delay of the holder in presenting it for payment unless failure of the bank. Now we will discuss about the crossing of cheques. There are several types of crossing. We will discuss one by one. General crossing, Section 123 of Negotiable Instruments Act, where a cheque bears across its face an addition of the word "and company" or abbreviation thereof between two parallel transverse lines, simply with or without the words non-negotiable, that is called general crossing. अगर एक चेक के ऊपर दो पैरेलल लाइन्स हो और उस लाइन में लिखा हो एंड कंपनी या उनका एब्रीविएशन, तो उसे जनरल क्रॉसिंग कहा जाता है. ये जरूरी नहीं कि उसके ऊपर नॉन नेगोशिएबल वर्ड्स लिखा हो. स्पेशल क्रॉसिंग, सेक्शन 124. Here, a check bears across lines on face an addition of the name of a bank, either with or without the words non-negotiable. इस केस में चेक के ऊपर क्रॉस लाइन के बीच में बैंक का नाम भी लिखा होता है. इसे कहते हैं स्पेशल क्रॉसिंग. नॉट नेगोशिएबल क्रॉसिंग, सेक्शन 130. A person who takes such check shall not have and shall not be capable of giving a better title to the check than the person from which he took the check. Account pay crossing. This is a cross check with the words account pay. An account pay crossing signifies that the drawer intends the payment to be credited to the pay's account only. Not negotiable account pay crossing. The instrument rendered not negotiable plus account pay crossing directs the collecting bank to collect it for the pays only and wants that if the amount is collected for someone else, he may be held liable for the damages. opening of crossing. The drawer has a right to cancel the crossing by writing the word pay cash and putting his full signature on the check. Friends, we have discussed the negotiable instruments. Now we will discuss about the parties related to the negotiable instruments. First of all, we will discuss about holder. The meaning of holder is given in section 8 of the Negotiable Instrument Act. It says, the holder of a negotiable instrument means any person entitled to possession of the instrument in his own name and to receive the amount due thereon from the parties liable thereto. In other words, holder means the payee or endorsee of the negotiable instrument, who is in the possession of it. The finder of a lost instrument payable to the bidder or a person in wrongful possession of such instrument is not a holder. Holder in value. Holder in value means, as regards all parties prior to himself, a holder of an instrument for which value has at any time been given. Our next term is holder in due course. Section 9 of the Negotiable Instrument Act. A holder in due course means a holder who takes the instrument bona fide for value before it is overdue and without any notice of defects in the title of the person who transferred it to him. Thus, a person who claims to be a holder in due course required to prove three conditions. 1. On paying a valuable consideration, he became either the possessor of the instrument if payable to bearer or endorsee thereof if payable to order. Second, he had come into the possession of instrument before the amount due thereunder become actual payable. Third, he had come to possess the instrument without having sufficient cause to believe that any defect existed in the title of transferor from whom he derived his title. A holder in due course will enjoy several privileges. These are, he gets a better title than that of the transferor. A holder in due course gets a better title than that of the transferor. Further, not only the holder in due course himself gets a good title free from all defects, but he also gives good title to all the subsequent holders. Once an instrument passes through the hands of a holder in due course, it is free from all the defects. Section 53 states that a holder of a negotiable instrument who derives title from a holder in due course has the rights thereon of that holder in due course. Thus, anybody who takes a negotiable instrument from a holder in due course can recover the amount from all prior parties, although he had knowledge of the prior defects. For example, no proper consideration was paid by some of the prior parties, or someone of them was a thief. It is important to note that a forged instrument, even if it passes through the hands of the holder in due course, cannot be cured of its defects because there is no defect of title, but there is complete absence of title. Privilege in case of inchoate stamped instruments, section 20. In the case of inchoate stamped instruments, if the holder or original payee fills more amount than that was authorized, he cannot enforce the instrument for the whole amount. Only actual authorized amount can be recovered. If such an instrument is transferred to a holder in due course, he can claim the whole of the amount so entered, provided that the amount is covered by the stamp affixed thereon. Thus, the defense that the amount filled by the holder was in effects of the authority given cannot be taken against a holder in due course. Liability of prior parties. All prior parties to a negotiable instrument, that is, its maker or drawer, acceptor, and intervening endorsers, continue to remain liable to a holder in due course, both jointly and severally. That is, he can hold any or all prior parties liable until the instrument is duly satisfied. Section 36. Whereas only preceding party is liable to a succeeding party if the succeeding party is only a holder. Privilege in case of fictitious bills. Section 42. When a bill of exchange is drawn in a fictitious name and is made payable to the drawer's order, that is, where both drawer and the payee of a bill are fictitious persons, the bill is said to be a fictitious bill. Such a bill is not a good bill and cannot be enforced at law. But the acceptor of such a bill is liable to a holder in due course, provided the latter can show that the first endorsement on the bill and the signature of the supposed drawer are in the same handwriting. Privilege when an instrument delivered conditionally is negotiated. When a negotiable instrument is endorsed or delivered conditionally or for a special purpose only, for example, as collateral security or for the safe custody, and not with the idea of transferring absolutely property therein, the property in the instrument does not pass to the endorsee, and he is merely a bailee with limited title and power of negotiating it. This, however, does not affect the rights of a holder in due course. That is, if such an instrument is negotiated to a holder in due course, the parties liable on the instruments cannot escape liability. Section 46 and 47. Estoppel against denying original validity of instruments. Section 120. The plea of original invalidity of the instrument cannot be put forth against the holder in due course by the drawer of a bill of exchange or cheque, or by the maker of a promissory note, or by an acceptor of a bill of exchange for the honor of the drawer. However, the aforesaid parties are not precluded from challenging the validity of the instrument on the ground that at the time of making the instrument he was a minor, or his signature had been forged, or the instrument is otherwise void ab initio. For example, where the promissory note is made payable to bearer, it is void and illegal as per the Reserve Bank of India Act. Estoppel against denying capacity of payee to endorsee. No maker of a note and no acceptor of a bill payable to order shall, in a suit thereon by the holder in due course, be permitted to deny the payee's capacity at the date of the note or the bill to endorse the same. Section 141. Thus, a holder in due course can claim payment in his own name, despite the payee's incapacity to endorse the instrument, As per section 51, only a holder or a person in lawful possession of the instrument is competent to endorse. Accordingly, a person who got the instrument for the gambling debt or for unlawful consideration cannot negotiate the same. However, the holder in due course enjoys a privilege in this regard, and he gets a good title even if he holds a negotiable instrument endorsed by a person who got the instrument for unlawful consideration, because section 121 provides that as against a holder in due course, no maker of a note and no acceptor of a bill payable to order shall be permitted to deny the payer's capacity to endorse the same. Let's have an example of inchoate stamped instrument. A signs his name on a blank but stamped instrument and gives to B with an authority to fill up as a note for a sum of rupees 4,000 only. But B fills it for rupees 5,000 and then transfers it to C for a proper consideration of rupees 5,000, who takes it in a good faith. Here, C is entitled to recover full amount of the instrument because he is holder in due course. But B, being a holder, cannot recover the amount because he filled in the amount in effects of his authority. Let's take an example of conditional instrument. If I give a check to a shopkeeper with the condition that he should not encash the check till he supplies me the goods, anybody encashing the check prior to fulfilling the condition is liable to return the money except the holder in due course. Let's have an example of better title to holder in due course. If P obtains an instrument payable to bearer by theft or fraud or for an unlawful consideration, he cannot sue on it. But if P transfers the instrument, being a bearer one, to R under circumstances for value in good faith which make R a holder in due course, R can sue on the instrument. The party liable to pay can take as against P the defense of theft or fraud, but as against R, he will not be allowed to take such a defense. Now we will discuss types of negotiable instruments. We can also say that classification of negotiable instruments. Time instruments. An instrument payable after a fixed time or on specified date is termed as time instrument. An instrument payable after happening of a certain event is also called as time instrument. Demand instruments. It is also called as at-sight instruments. When no time of payment is specified, it is payable on demand. When it is expressed to be payable on demand or at a sight or at presentation, it is demand instrument. Bearer instruments. A negotiable instrument is said to be bearer instrument if it is expressed to be so payable, or when the only or last endorsement is in blank. Order instrument. When it is expressed to be payable to the order, or when it is expressed to be payable to a particular person and does not contain the words prohibited or restricting its transfer, that is order instrument. Ambiguous instruments. Section 17 of Negotiable Instrument Act. Ambiguous instruments mean an instrument which may be treated as a bill or as a promissory note. In such a case, the holder may either treat it as a bill or promissory note, but once he has made his choice, the instrument shall henceforth be treated accordingly. In the following cases, instrument is an ambiguous instrument. When the drawer and drawee of a bill are the same person. When the drawee of a bill is a fictitious person. When the drawee of a bill is a person not having capacity to contract. Inchoate Instrument. It is an instrument that is signed and duly stamped, but otherwise wholly or partially blank. When one person sign and deliver properly stamped by wholly or partly blank instrument, such incomplete instrument is called inchoate instrument. He thereby gives prima facie authority to the holder to make or complete instrument for any amount specified therein. ESCROW. When a negotiable instrument is endorsed and delivered conditionally or as collateral security, it is called ESCROW. In this case, property in the instrument does not passes to the endorsee. He is merely a bailee with limited title and power of negotiating it. However, it does not affect the right of a holder in due course. Forged instruments. As a general rule, a forged signature is worthless, having no legal impact. The holder of a forged instrument cannot enforce payment, therefore, the true owner can compel debtor to pay it again to him. Even a holder in due course cannot claim payment on forged instruments. Accommodation Bill. As cleared by its name, Accommodation Bill is a bill which comes into existence to accommodate. Let us understand the Accommodation Bill with the help of an example. X draws a bill payable to himself on Y. Y accepts the bill without consideration just to accommodate X, to enable X to raise money from market by negotiating the bill in the market. This is Accommodation Bill. Though Y accepts the bill, X is primarily liable to the bill. He cannot demand amount from Y. However, if X transfers the bill after maturity to Z for good consideration and Z becomes the holder in good faith, Z is entitled to recover the amount. These points should be noted in case of an Accommodation Bill. The drawer does not give any consideration to the drawee, but the bill is drawn with an object of providing financial help to the drawer or to both drawer and drawee. Thus, there is no relationship of creditor and debtor between drawer and drawee. In Accommodation Bill, there is no obligation for payment. The accommodating party is liable on the bill on any subsequent holder for value, even if the holder knew at the time of taking the bill that it is an accommodation bill. Section 43. An accommodation bill can be negotiated after maturity with all benefits of a holder in due course. Section 59. Non-presentation of an accommodation bill to the acceptor for payment does not discharge the drawee. Students, now we will go further. Now we will discuss about the maturity of negotiable instruments. Maturity is the date of any instrument at which its payment becomes due. Any instruments are at maturity on the third day after the day on which it is expressed to be payable. What are the rules for calculating maturity? These are: instrument will be payable after a stated number of months, 3 days after the corresponding date of the month of payment. If the month has no corresponding date, it will be payable on the last day of the month. It will exclude the day on which instrument is presented for acceptance or sight or on which the event happens. If maturity day is a public holiday or Sunday, immediate preceding business day shall be deemed as maturity day. If it is an emergency holiday, then it will be on subsequent date. If instrument is payable on installments, 3 days grace will be allowed on each installment. Our next topic is negotiating of negotiable instruments. Here we will discuss two aspects: negotiation of negotiable instruments and assignment of negotiable instrument. Negotiation of negotiable instrument. Negotiable means transfer of a negotiable instrument by one person to another in order to make the transferee the holder of the instrument. Negotiation may be made by delivery or by endorsement and delivery. Assignment. Assignment of a negotiable instrument means transfer of ownership of the instrument from one person to another, means assigner to assignee, whereby the assignee becomes entitled to recover the amount due on the instrument from the parties liable to pay. What are the differences between negotiation and assignments? Let's discuss. There are 4 major points. 1. Consideration. In negotiation, consideration is presumed, but in assignment, consideration must be proved as in case of any other contract. Second, title. In negotiation, the title of transferee, means holder in due course, is better than that of the transferor. But in case of assignment, the title of assignee is subject to the title of the assigner. Third point is notice of transfer. In negotiation, notice of transfer to debtor by the transferee is not necessary, whereas in case of assignment, the assignment does not bind the debtor unless notice of the assignment has been given by assignee to the debtor and the debtor has expressly or impliedly assented to it. Fourth point is mode. in case of negotiation. In case of bearer instrument, it can be negotiated by mere delivery, and instrument payable on the order are negotiated by delivery and endorsement. But an assignment can only be made in writing, either on the instrument itself or in a separate document. Now, we will discuss the different provisions relating to negotiation. Negotiable back. An instrument is said to have been negotiable back when a person who has been a party to negotiable instrument takes it again. Let's have an example. Suppose A endorses a negotiable instrument to B. Then B endorses the same instrument to C. Again, C endorses the instrument to D. Again, D endorses the same instrument to B. Here, B is the person who is the prior party to the instrument. On account of this last endorsement, B should have a right to claim money from C and D. The rule is that every prior party is liable to every subsequent party. Every subsequent party may sue every prior party. Hence, B can sue D, D can sue C, and C can sue B. To prevent this, Section 52 of Negotiable Instrument Act enacts an exception to the general rule to provide that holder in due course may sue all the prior parties thereto. Hence, B cannot sue C or D, but he can sue A. That was an example of negotiable back. Dear students, let's discuss the liabilities of parties. Here, the parties means all the parties which are directly or indirectly related to negotiable instrument, namely drawer, drawee, legal representative, acceptor, endorser, holder, etc. Liability of a legal representative. Section 29. The legal representative of a deceased person who signs his own name on the instrument is personally liable to the entire amount, but he can expressly limit his liability to the extent of the assets received by him as legal representative. Liability of a drawer. Section 30. The drawer's liability is conditional and secondary. It arises only in the event of dishonor by drawee or acceptor. Once there has been dishonor and a notice of dishonor has been served on the drawer, he is bound to compensate the holder, whatever be the state of account between himself and the drawee and the acceptor. It may be noted that the drawer may, by an express stipulation in the instrument, limit or exclude his liability. Liability of drawee of cheque. Section 31. The drawee of a cheque is always a banker. It is a duty of the banker to pay the cheque, provided he has sufficient funds of drawer in his hands and the funds are properly applicable to such payment. If the banker refuses payment without any sufficient cause being shown, he must compensate the drawer any loss caused by such improper refusal. The amount of compensation that the banker is liable to pay is to be measured by loss or damage, say loss of credit suffered by the drawer, the principle is the lesser the value of cheque dishonored, the greater the damage to the credit of drawer. Now, the question is, can a banker refuse a cheque? The answer is yes. A banker is justified to dishonor the cheque in the following cases. If the cheque is undated, if it is stale, that is, if it has been not presented within prescribed time, if it is inchoate and not free from reasonable doubt, if the cheque is post-dated and it is presented before that date, and if the drawer's funds are not properly applicable to the payment of the cheque, if the banker receives the notice of customer's insolvency or lunacy, if there is any order by court for attachment of the account, if the banker has received the notice of death of the drawer, if notice of closure of account has been served by either parties, and if it is contained material alterations, irregular signature or irregular endorsement. In these cases, banks can refuse a cheque. Liability of maker of note and acceptor of bill. Section 32. The maker of a promissory note is bound to pay the amount on maturity. In case of default in making payment, he is liable to compensate any party to the note for any loss sustained by reason of such default. Under Section 32 of the Act, the liability of an acceptor arises only when he accepts the bill. Liability of an endorser. Section 35. Every endorser who endorsed an instrument before its maturity is liable to the parties that are subsequent to him, and his liability arises only if there is a default by the party who is primarily liable to pay the instrument on maturity. Liability of parties to holder in due course. Section 36. Every prior party to an instrument is liable to holder in due course until the instrument is satisfied. Thus, the maker and endorsers of a note are jointly or severally liable for the payment and may be sued jointly. Effect of forged endorsement on acceptor's liability. Section 41. As per Section 41 of the Negotiable Instrument Act, the acceptor cannot be relieved from the liability knowing that the endorsement is forged. Liability of acceptor of a bill drawn in a fictitious name. Section 42. The acceptor is not relieved from liability by proving that the drawer is fictitious. Suppose X uses a fictitious name in drawing a bill upon Z. Then he endorses the bill in the same fictitious name to Y, who presents the bill to Z for acceptance. Now, if Z accepts the bill, he will be liable for payment in spite of fact that the name of drawer is fictitious. liability on an instrument drawn, etc., without consideration. As per Section 43 of the Negotiable Instrument Act, such an instrument is void and creates no obligation of payment between the parties to the transactions. For example, if a promissory note is delivered by the maker to the payee as a gift, it cannot be endorsed against the maker by the payee. If the possessor endorses it to another person, the endorsee would not be entitled to claim payment unless he is a holder in due course. Bouncing of cheque or dishonour of a cheque. With effect from 1st April 1989, dishonour of cheque due to insufficient funds is an offence. Section 138 to Section 142 of the Negotiable Instrument Act provide for criminal penalties in the event of dishonour of cheque for insufficient funds. The drawer under Section 138 will be punishable with an imprisonment up to 2 years or with a fine twice the cheque amount or with both. However, in order to attract the penalties, the following conditions must be satisfied. 1. The cheque should have been dishonoured due to insufficiency of funds in the account. Please note, in case of stop payment, it shall be deemed to have been so dishonoured for insufficiency of funds unless stop payment can be justified. Second, the payment for which the cheque was issued should have been in discharge of a legally enforceable debt or liability in whole or part of it. Third, the cheque should have been presented within 3 months from the date on which it is drawn or within its validity period, whichever is earlier. Fourth, the payee or the holder in due course of the cheque should have given notice to drawer demanding payment within 15 days of receiving information of dishonour. The drawer is liable only if he fails to make payment within 15 days of such notice. The payee should have been made complaint within 1 month of the course of the action. For better understanding, let's see this question. A drawer of a cheque, after issuing the cheque, informs the drawee not to present cheque as well as informs bank to stop payment. Does it constitute an offence under the Act? Answer is, once a cheque is issued by the drawer, a presumption under Section 139 follows. Merely because the drawer issues a notice thereafter to drawee or to the bank for stoppage of payment does not discharge the drawer from his liability. Hence, he shall be deemed to have committed an offence. Dear students, now we will discuss the rights and the obligations of the parties. What are the rights and obligations of the finder of lost instrument? The finder or the endorsee of finder of lost goods does not get good title of it. He is bound to return the instrument to the real owner. The true owner can recover the amount from the finder. If the possessor of lost instrument is a holder in due course, he is entitled to receive the amount due thereon from acceptor or holder or any party prior to that holder. The possessor or endorsee is also entitled to receive amount if he got the endorsement of instrument from a holder in due course. What are the rights and obligations of a person who had obtained the instrument by unlawful means? If the instrument obtained by fraud or unlawful means, the possessor is not entitled to receive the amount under it from such maker, acceptor, holder, or any party prior to such holder. But a holder in due course will get a good title even if he gets a stolen negotiable instrument. Let's have an example. Suppose X steals a bill from acceptor. X does not get any good title of it. If X collected the proceeds of bill, the acceptor can recover it from X. But if X endorses the bill to Y against value, and if Y is holder in due course, Y can recover the money from X, but not from any other party. Now we will discuss about the forged instruments. Forged instruments. As a general rule, a forged signature is worthless, having no impact. The holder of a forged instrument cannot enforce payment, therefore. The true owner can compel debtor to pay it again to him. Even a holder in due course cannot claim payment on forged instrument. In continuation of forged instruments, there are some important points to be noted. 1. Person who forges an instrument gets no title on the instrument. Even holder in due course cannot claim the good title. It is important to note that a forged instrument, even if it passes through the hands of a holder in due course, cannot be cured of its defects, because there is no defect of title, but there is complete absence of title. ध्यान देने वाली बात यह है कि फोर्ज इंस्ट्रूमेंट्स के केस में होल्डर इन ड्यू कोर्स को भी कोई बेनिफिट नहीं मिलता, क्योंकि यहां टाइटल के डिफेक्ट की बात नहीं है, बल्कि यहां टाइटल है ही नहीं. सेकंड पॉइंट, द होल्डर ऑफ इंस्ट्रूमेंट who has acquired it after dishonor has, as against the other parties, only rights thereon of his transferor. If the instrument is acquired after maturity, the holder of an overdue instrument is affected by the defect in the title of his transferor. Let us have an example. P is the drawer and Q is the drawee and acceptor. Q deposits some goods with P as collateral security. The bill not having been paid on maturity, P sells the goods and retains the money. Now, P endorses the bill after maturity to R. R, having rights of P, cannot recover money from Q. But if R was a bona fide endorsee before maturity, then he could realize the money from Q. Another point in forged instrument is, in an accommodation bill or note, a defect in the title of the transferor does not affect the title of the holder acquiring after maturity. Our next topic is hundi. What is hundi? Hundis are negotiable instruments written in Hindustani language. Sometimes they are in the form of promissory notes, but more often they take the form of bill of exchange. The provisions of the Negotiable Instrument Act apply to hundi unless there is a local usage to the contrary. There are various types of hundis. Darshani hundi. It is one payable at sight, like a demand bill. Miyadi hundi or muddati hundi. It is one payable after a specified period of time, like a time bill. Shah Jog hundi. This is a hundi made payable only to Shah. Shah means respectable person. Naam Jog hundi, where a hundi is made payable to a specified person, it is called Naam Jog hundi. Jokhmi hundi. The term jokhmi means against risk. A jokhmi hundi therefore is a combination of a bill of exchange and an insurance policy. Dhani Jog hundi. Dhani means honor. A Dhani Jog hundi is payable to Dhani honor only. Students, let's move further. Let's discuss the presentation of instruments. Presentation means showing a negotiable instrument to the drawee, acceptor or maker for acceptance, sight or payment. Presentation for acceptance. A bill payable on demand or at a sight or on certain fixed date need not to be presented for acceptance unless it is specifically agreed that such a bill is to be presented for acceptance. But presentation of acceptance is obligatory in case of a bill payable some period after sight or after presentation, or when there is an express stipulation in the bill that it shall be presented for acceptance. Acceptance of a bill means putting signature on the bill by the drawee with a view to signifying his assent for the payment of the amount of the bill on maturity. Acceptance is required only in case of bill of exchange, but every bill is not required to be presented for acceptance. Acceptance and presentation of acceptance is compulsory only in case of bills payable after sight. What are the modes of acceptance? There are two modes: general acceptance, qualified acceptance. What is general acceptance? When the drawee, while accepting the bill, does not attach any condition or qualification to it, it is called general acceptance. And what is qualified acceptance? The acceptance is qualified when it is given subject to some conditions or qualifications. The holder may refuse to take the qualified acceptance and treat the bill as dishonored by non-acceptance. But if he takes it, he does so at his own risk and discharge all parties prior to himself unless he obtains their consent to such acceptance. To whom the presentation for acceptance should be made? Presentation for acceptance may be made to the drawee or his duly authorized agent, his legal representative if the drawee has died, his assignee if the drawee has been declared insolvent, and all the drawees if there are several drawees unless they are partners or agents of one another. In the following cases, presentation for acceptance excused. If the drawee is a fictitious or incompetent person, there is no need to present the document for the acceptance. Second, if the drawee cannot be found after reasonable search. Third, although the presentation has been irregular, acceptance has been refused on some other grounds. What is acceptance for honor? Acceptance for honor means the acceptance given by some stranger when the original drawee refuses to accept or to give better security when demanded by a notary. A stranger may accept the bill of the honor of any party already liable thereto. Such stranger is called an acceptor for honor or acceptor supra protest. An acceptance for honor will be valid only if the following conditions will be satisfied. That the bill has been noted or protested for non-acceptance or better security. That such an acceptance has been made with the consent of holder. That the acceptor for honor is not already liable on the bill. That the acceptor is for the honor of any party already liable on the bill, and that the acceptance is by writing on the bill. Presentation for sight. A promissory note payable after sight must be presented to the maker for sight to determine the maturity. It should be present during office hours and on a business day. If the maker cannot be found after a reasonable search, presentation is excused and the note may be treated as dishonored. In default of such presentation, the maker is not liable to pay anything to the holder. Presentation for payment. Promissory note, bill of exchange, and checks must be presented for payment to the maker, acceptor, or drawee thereof, respectively, by or on behalf of the holder. If default is made, the parties other than parties primarily liable are discharged of their liability. This is as per Section 64 of the Negotiable Instrument Act. Presentation for payment. When it should be made and where it should be made. Presentation for payment must be made during usual business hours. It must be made at the place of payment specified in the instrument. If no place is specified, it should be made at a place of business or residence. And in any other case, wherever the party liable to pay can be found. Now the question is, to whom the presentation for payment should be made? The presentation for payment should be made to the drawee, maker or acceptor, as the case may be, or to their authorized agent. It should be made to legal representative if drawee, maker or acceptor has died. it should be made to the assignee where Drawee, maker or acceptor was declared insolvent. Delay in presentation for payment is excused if it is caused by circumstances beyond the control of the holder. It should be noted that presentation for payment is not necessary in the following cases: where it is intentionally prevented by the maker, Drawee or acceptor, or where the business of the maker, Drawee or acceptor is closed, or he cannot be found after a reasonable search, or there is no person at the place of payment, or where there is a promise to pay notwithstanding non-presentation. Presentation for payment is not necessary where payment is expressly or impliedly waived, or where the bill is dishonored by non-acceptance, or where the Drawee is a fictitious person, or where the presentation becomes impossible. As we already discussed acceptance for honor, now we must know about the payment for honor. What is the payment for honor? Just as a bill may be accepted for the honor of a party to the bill, it may also be paid for the honor of a party liable to pay the bill, and after payment he can recover from that person or any party prior to him. Dishonor by non-acceptance, section 91. First of all, we must know what is the dishonor. All bills may be dishonored by non-acceptance or by non-payment. All the notes and checks may be dishonored by non-payment. Now, section 91 of the Negotiable Instruments Act says a dishonor by non-acceptance may take place in any one of the following circumstances: when the Drawee either does not accept the bill within 48 hours of presentation or refuse to accept it, when one of the several Drawees, not being partners, makes default in acceptance, when the Drawee gives a qualified acceptance, when presentment for acceptance is excused and the bill remains unaccepted, when the Drawee is incompetent to contract. When the instrument will be dishonored by non-payment, section 92 of the Negotiable Instrument Act states that an instrument is dishonored by non-payment when the party primarily liable, an acceptor of a bill, maker of a note or Drawee of a cheque, make default in payment. An instrument is also dishonored for non-payment when presentment for payment excused and the instrument, when overdue, remains unpaid under section 76 of the Negotiable Instrument Act. Dear students, here we must know distinction between dishonor by non-acceptance and non-payment. If a bill is dishonored for non-acceptance, there is no right of action against the Drawee, as he is not a party to the bill. the holder of bill can proceed only against the drawer or endorser, if any. And on dishonour by non-payment, the drawee can be sued. What are the effects of dishonour of a Negotiable Instrument Act? As soon as a negotiable instrument is dishonoured, the holder becomes entitled to sue the parties liable to pay thereon. The drawer of cheque, maker of note, acceptor and drawer of bills, and all the endorsers are liable severally or jointly to the holder in due course. When a negotiable instrument is dishonoured, notice of dishonour must be sent. Notice of dishonour must be given by the holder to any of the parties to the instrument who remains liable thereon. Section 93. अगर कोई negotiable instrument dishonor होता है तो हर पार्टी को नोटिस जाना चाहिए. Further, any party receiving notice of dishonor must also transmit the same within a reasonable time to all parties in order to render them liable to him. He cannot sue any prior party if notice has not transmitted. So, it must be noted that it is very important to send a notice of dishonor if the holder wants to take legal action against the defaulter. Now the question is, to whom the notice should be given in case of dishonor of negotiable instrument? Without giving notice of dishonor, a holder cannot take any legal action against the defaulter. Notice of dishonor must be given to all parties other than the maker of a note, acceptor of a bill, or drawee of a cheque, to whom the holder seeks to make liable, or to their duly authorized agent. Where there are two or more persons jointly liable as drawer or endorser, notice to any one of them is sufficient. And in case of death of person, notice must be given to his legal representative, or where he has been declared insolvent, it must be given to his official assignee. Section 97 of the Negotiable Instrument Act. In case negotiable instrument is dishonored, notice of dishonor must be given within reasonable time. Now the question is, what is the reasonable time? If the holder and the party to whom notice of dishonor is given carry on business or live in same place, such notice shall be deemed to given within reasonable time if it is given so as to receive on day of dishonor or day after dishonor. And if the holder and the party to whom notice of dishonor is given carry on business and live in different place, such notice shall be deemed to be given within reasonable time if it is dispatched by the next post or on the day next after the day of dishonor. What are the circumstances when notice of dishonor is not necessary? In a suit against the drawer or endorser on an instrument being dishonored, notice of dishonor is a material part of a cause of action. However, in the following cases, notice of dishonor is not necessary. These cases are: 1. When the necessity of notice has been dispensed with by an express waiver by the party entitled to it. For example, when a drawer of a bill informs the holder that the bill will be dishonored on presentment, the notice of dishonor is said to have been dispensed with. Second condition is when the party charged would not suffer damage for want of notice. Third condition, when the party entitled to notice could not be found after due search. Fourth, when one of the drawer is acceptor. Fifth condition, when there was accidental omission to give the notice, provided the omission has been caused by unavoidable circumstances like death, dangerous illness, or sudden accident of holder or his agent. Sixth condition is in the case of a promissory note which is not negotiable. 7. When the party entitled to notice promises to pay unconditionally. What are the consequences of not giving notice of dishonor? Any party to a negotiable instrument to whom notice of dishonor is not sent by the holder is discharged from his obligation unless no notice of dishonor is required to be sent. If a negotiable instrument is dishonored, in order to take legal action against the defaulting party, noting and protesting are necessary. Now, what is the noting? Noting is the process of recording the fact and reasons of dishonor of a negotiable instrument by the notary public. According to section 99 of Negotiable Instrument Act, when a promissory note or a bill has been dishonored by non-acceptance or non-payment, the holder may cause such dishonor to be noted by notary upon the instrument or upon a paper attached thereto. Hence, noting means recording of the facts of dishonor. And noting must be made within reasonable time after dishonor and must specify the date of dishonor, the reason assigned for such dishonor, and the notary's charges. And what is protesting? Protest is a formal certificate of dishonor issued by the notary public to the holder of a bill or note on his demand. Section 100 of Negotiable Instrument Act. The important difference between noting and protesting is that noting consists of recording the facts and reasons of dishonor of negotiable instrument upon the instruments, whereas protest is the certificate as to the fact that the instrument has been dishonored. Discharge of an instrument. When a negotiable instrument is said to be discharged? A negotiable instrument is said to be discharged when it becomes completely useless. That is, no action on that will lie and it cannot be negotiated further. Second, it will be discharged when the party primary liable on the instrument makes the payment in due course to the holder at or after maturity. Section 78 of the Negotiable Instrument Act. An instrument will be discharged when the party primary liable becomes insolvent. The instrument will be discharged. And when the holders cancel the instrument with an intention to release the party primary liable there from their liability. Discharge of one or more parties. A party is said to be discharged from his liability when his liability on the instrument comes to an end. party can be discharged by the following methods. By cancellation, when the holder of a negotiable instrument deliberately cancels the name of any of the parties, the party whose name and subsequent party whose name is so cancelled is discharged from the liability. By release, if the holder of a negotiable instrument releases any party to the instrument by any method other than cancellation, the party so released and all parties subsequent to him are discharged from the liability. By allowing drawee more than 48 hours to accept, Section 83. If a holder of a bill of exchange allows drawee more than 48 hours exclusively of public holiday to consider whether he will accept the same, all parties not consenting to such allowance are thereby discharged from the liability. By taking qualified acceptance, Section 86. If a holder of a bill agrees to a qualified acceptance, all prior parties whose consent is not obtained to such an acceptance are discharged from liability. By not giving notice of dishonour, any party to the negotiable instrument other than the party primary liable to whom notice of dishonour not sent by the holder is discharged from liability as against the holder unless the circumstances are such that no notice of dishonour is required to be sent. The next point is by not presentment for acceptance of bill. Section 61. When a bill of exchange is payable after sight, its holder must present for acceptance. If the maker makes a default in making such presentation, the drawer or all endorsers who were liable towards such a holder are discharged from their liabilities towards him. Next point. By delay in presenting cheque, Section 84. It is the duty of the holder of cheque to present it for payment within reasonable time or within the validity of the cheque. If he fails to do so, the drawer is discharged from his liability. By negotiating back of a bill. When a bill of exchange comes back to the acceptor by process of negotiation and he becomes its holder, it is called negotiation back and his liability will be discharged. Multiple choice questions. Students, read the questions carefully, answer the questions honestly, and do your self-assessment. All the best. Question 1. The undertaking contained in a promissory note to pay a certain sum of money is A. Conditional, B. Unconditional, C. May be conditional or unconditional depending upon the circumstances, and D. None of the above. Student, just tell. The correct answer is option B, unconditional. Reason: as per Section 4 of the Negotiable Instrument Act, a promissory note is an instrument containing an unconditional undertaking signed by the maker to pay a certain sum of money only to and to the order of a certain person or to the bearer of the instrument. Hence, by virtue of Section 4, the correct answer is option B, unconditional. Question 2. Which of these is not a negotiable instrument as per the Negotiable Instrument Act 1881. Option A, Bill of Exchange. Option B, Delivery Note. Option C, Bearer Cheque. And option D, Share Certificate. The correct answer is option D, Share Certificate. Just remember Section 13 of the Negotiable Instrument Act. Section 13 mentions only three kinds of negotiable instruments, namely bills, notes and checks. Hence, share certificate is not mentioned anywhere in Section 13 and it is not a negotiable instrument. Question 3. Which of the following is not a payment in due course under Negotiable Instrument Act 1881? A. Payment should be made in accordance with the apparent tenor of the instrument. B. A payment is made on instrument before the date of maturity. C. Payment is made to the possessor of the instrument. And D. Payment made in good faith and without negligence. The correct answer is option B. A payment is made on instrument before the date of maturity. The instrument should be payable either at maturity or after maturity. An instrument paid before maturity is not a payment in due course. Question 4. X drew a bill on Y and sent it to Y for acceptance. In which of the following instances it is a valid acceptance? A. Y signs on bill and keeps it with him. B. He writes accepted on the back of bill but does not put his signature on the bill. C. He puts his signature on face of bill and returns it to X. D. He writes accepted on the face of the bill but does not put his signature. The right answer is option C. He puts his signature on face of bill and returns it to X. When the drawee signifies his consent in writing by signing across the face of bill with or without the word accepted and returned to the holder, the bill is said to have been accepted. Hence, the right answer is option C. Question number 5. In which of the following situations could a bill of exchange not be negotiated? Option A. The time to pay is not determinable. B. The promise to pay is conditional. C. The amount to be paid is the amount owing on account. D. All of the above. The correct answer is option D. All of the above. Section 5. In a bill, time sum payable should be certain and it should be an unconditional order. Question number 6. X made a note payable to the order of his son Y as a birthday gift payable after 1 month. Y presented the note after 3 months and X refused to pay. Can Y sue for payment? Options are yes, because a note, unlike a check, cannot become stale dated. Option B, yes, because the note is a negotiable instrument and that is required to pay. Option C, no, because a note, like a check, can become stale dated. And option D, no, because the note was gratuitous, so it is not binding for the lack of consideration. Here, the correct answer is option D, no, because the note was gratuitous, So it is not binding for the lack of consideration. Also, it is not a payment against any liability. Question number 7. Which of the following is not a part of the criteria for a holder in due course? A. The instrument is held by the party immediate to the promisor. B. The instrument is taken by someone or through someone who has given consideration for it. C. The instrument is taken complete and regular on its face. D. The instrument is taken before it is overdue and without notice of any dishonour. The right answer is option A. The instrument is held by a party immediate to the promisor. It is not a part of the criteria of a holder in due course. Question number 8. B issued a cheque of rupees 10,000 in favor of S. B had sufficient funds in his account. The cheque was not presented within reasonable time. In the meantime, bank became insolvent. Now, what will be the legal position? Option A. S can recover money from B. Option B. B is discharged from his liability. Option C. S can recover from official assignee of the bank. Option D. S can sue B and bank jointly. The correct answer is option B. B is discharged from his liability. It is the duty of holder to present cheque to the bank within reasonable time. If the holder does not present the cheque at the bank in time, the position of bank may become unsound and it may not be possible for the bank to honor the cheque. In this case, driver is not liable if bank refuses to honor the cheque on presentation. Section 72. Last question, question number 9. P draws a bill of rupees 10,000 on Q. Q accepts it. On maturity, the bill was dishonored. P filed a suit against Q. Q proved that the bill was accepted for value of rupees 7,000 and balance rupees 3,000 as an accommodation bill. Now, option A. P can recover rupees 10,000 from Q. Option B. P can recover rupees 7,000 from Q. Option C. P cannot recover anything because bill is confusing. And option D. Bill is void ab initio. The correct answer is option B. P can recover 7,000 from Q. In Accommodation Bill, the relation between the drawer and drawee is not that of creditor and debtor. Hence, P cannot recover rupees 3,000 which was for accommodating. Section 44. When consideration for which a person signed a note or bill or cheque is partly absent, the claimed amount is proportionately reduced. Hence, the correct option is option B. P can recover only rupees 7,000 from. So, dear students, today we discuss the basic of negotiable instruments, the types of negotiable instruments, dishonour of negotiable instruments, different parties of negotiable instruments and their liability, and discharge of negotiable instruments and the discharge of parties. That was the end of e-lecture on the topic the Negotiable Instruments Act 1881. Thank you very so much and I wish you a good luck for a very bright future ahead. Thanks again.